All right, good evening, everyone. My name is Brant Helwig. I'm a member of the tax faculty here at NYU Law School, and I also have the privilege of serving as the faculty director of the graduate tax program. It's my pleasure to welcome you. Many of you welcome you back to NYU Law School, but also to welcome everybody to our third annual Jerry Manning Tax Salon Series that we host here on an annual basis at NYU Law School. Before we get into our conversation this evening, I want to take a few words just to remark on Jerry Manning and the contributions that he made to NYU Law. Jerry was a graduate of the NYU Law class of 1952. Shortly after graduating, he joined the law firm of Strook and Levan, where he practiced in the estate planning field for his entire career. He authored the definitive treatise on estate planning in the field. The name of the treatise is Manning on Estate Planning. That treatise is currently being updated, and it's in its 7th edition now. But Jerry contributed to the strength of our tax program at NYU Law in a number of ways, in addition to the significant contributions that he made to the school. He served as an adjunct professor in the tax program for over 40 years. And for 25 years, he taught the capstone class on estate planning. So I want to take this occasion to express my personal and our collective gratitude to members of Jerry's family for the establishment of this Salon Series. And it really is a wonderful way for us to have an additional avenue to engage our alumni, to engage our students, and to engage practitioners on current tax topics, and that's the goal of what we're here to do today. With that in mind, let me introduce our distinguished Salon Speaker Series this year, Amy Heller. Amy is a partner in the New York office of the global law firm Skadden Arps, Slate, Meagher, and Flom, where she serves as the co-head of the Private Clients and Trust and Estates Practice Group. Amy's also a partner in the firm's tax practice. Amy received her undergraduate and law school degrees from Harvard University. And I think that was all in the lead up to her most impressive academic accomplishment, and that is receiving her LLM degree from NYU in 2009. And from what I understand, we actually had to hustle to get her degree granted because not long after she officially completed the program, we drafted her to be an adjunct professor. She started off teaching like one of the best courses that exist, right? The Income Taxation of Trust and Estates 2, as if one was not enough. We have a second one on grantor trust. Amy taught that for several years. And currently she's teaching an advanced course on international estate planning. So Amy's certainly been a fan favorite among our students for years, and we really appreciate the contributions that she continues to make to our tax program. So as part of this Salon Speaker Series, our goal is to have some interesting current tax event that we can discuss, and then maybe along the way have questions from the crowd. So our goal is for this to be conversational. The topic that we're going to look at in today's presentation, today's conversations, we're looking at the looming changes that are on the horizon at the end of 2025. In this case, of course, there's a number of changes that are on the horizon in terms of sunsets related to the Tax Cuts and Jobs Act of 2017. Here we're looking at the sunsets that will affect estate planning practice and thinking about, well, how do we accommodate these looming changes when we really don't know what's going to happen, right? We know the legislation is scheduled to end. Based on past experience, that turns out usually to not be the case. On the other hand, what we're looking at, if the legislation is going to change, that's going to obviously take some positive legislative action, right, which might be difficult to achieve in the current political environment. So you don't really know, right? And so we're going to think of well, what are some opportunities for us to plan in this arena that would accommodate that looming legislative change, but maybe also build in some flexibility if our whatever bet we make on what's going to happen, if that turns out not to be the case. So I think that's the broader idea of the conversation today. And once we get through with maybe some more of the technical stuff, I did want to I asked Amy to speak a little bit about her experience in the tax program and how that has, animated, assisted her in her practicing career. So, it's really nice to have everybody here. It's great to see some of our current JD students, LLM students, some of our recent alumni. Fantastic to meet some students that are in our online programs where we don't really get to see one another on a regular basis. And it's wonderful to have so many of you who've returned to the school for your reunion weekend. This is a great way to kick that off. So please join me in welcoming Amy Heller as our Salon Speaker Series.
So thank you very much for coming tonight, and thanks again for this very nice introduction. I'm really honored to be here, in part due to the particular program, the Jerome Manning 52 Tax Salon. When I graduated from law school and then from the LLM program at NYU, Jerry Manning was a living legend in the tax and estate planning field. He's truly one of the giants in this area on whose shoulders an entire generation of lawyers like myself stand. So it's really a privilege to be here and speaking at his salon. So I'm going to spend some time now, as Professor Hellwig said, talking about estate planning in view of changes to the estate and gift tax laws that are scheduled to take effect at the end of 2025. And I'm going to also discuss how state trust laws have evolved to enhance our ability to plan flexibly for these looming and uncertain changes. Just so that I have a sense of who's in this room, how many of you are current NYU tax LLM students who haven't had a lot of practice experience previously? Okay, thanks. And how many of you are practicing estate planning lawyers or practicing in a closely related area? Okay, so we have a range of people in this room. Okay, so for those of you who are not practicing in the estate planning field or are not taking estate and gift tax related classes currently, here are a few basics of the estate and gift tax. So the estate and gift tax rate currently is 40%, and this 40% tax applies to gifts that an individual makes during her lifetime or assets that the individual holds at death, unless some kind of exclusion, deduction, or credit applies. Now, these exclusions, deductions, and credits are very significant, and at this point, they allow most Americans to transfer all of their assets free of any gift or estate tax at all. The most significant of the credits is called the so-called unified credit. And in 2024, this credit effectively exempts about $13.6 million of a U.S. individual's assets from gift or estate tax. So the $13.6 million can be used during life, right? So I can give away $13.6 million to anyone in my lifetime without paying a gift tax. Or this exemption can be used at death. So if a U.S. individual has not made any gifts during her lifetime and she passes away this year, the first $13.6 million of property can be bequeathed to anyone in the world with no estate tax. And this gift and estate tax exemption also can be used partially during life and then partially on death. Under the current law, spouses effectively can combine their $13.6 million exemptions. So this means that a couple, both of whom are U.S. persons, they can currently pass more than $27 million to their children or other descendants or any beneficiaries without paying any gift or estate tax. And so this means for now that the gift and estate tax applies only to Americans who are very, very wealthy. Now, even those of you who aren't practicing in this area, you're probably aware, or you may be aware, that under the current law, the estate and gift tax exemptions are scheduled to be cut in half at the end of next year. And the way the law works, if you give assets this year equal to the current $13.6 million exemption amount, your gift is grandfathered. So what I mean is just that when the exemption amount is cut in half, no portion of your gift is going to be clawed back and subject to gift tax at that time or subject to estate tax when you die. And so this is why there's buzz in the estate planning community right now and in the popular press about why it's important to make gifts now, right? Now those of you who like me have been practicing in this area for more than a few years, you know we've been through this rodeo before. Ever since I started practicing, the estate and gift tax exemption amounts have been in flux. So what I have up here is a chart that shows the estate tax exemption amounts over the last approximately 25 years. When I started with 2001, that was the year that I was a summer associate. And at that time, the estate and gift tax exemption was $675,000 per person. And as we said, now it's $13.6 million per person. And in between...
It is almost laughable to say that number, right?
I mean, just...
I get to go back when it was $600,000 before we had any inflation adjustments up to... And I can also remember when it was a big deal when the... what was then the... applicable exclusion amount went from 600 to 625 right there. But that was like the buzz in like whatever it was, 1998.
That's because you're just a few years older than I am. So you see from this chart, like there's been a fair bit of fluctuation, and right, most notably, just looking at this, in 2010, the estate tax effectively was repealed for a year. And so when I put this chart together for this evening, one thing that struck me is that as much sort of flux as this chart reflects, it doesn't sort of fully reveal the uncertainty of estate planning throughout this period. So what do I mean by this? So this is like the hindsight chart, right? And if I'd had this chart when I started practicing in the early 2000s, like it might have been easier to plan than if you didn't have this chart and you're looking at it only in hindsight. So really the entire period of my practice has been characterized by legislation that's been in effect for a particular period, and then it's expiring or sunsetting with a great deal of uncertainty about what's coming next. So, okay, over the same 20-year period or so, 20-plus year period, there have also been a lot of changes, many would say innovations, in state trust laws. And these innovations have been important to estate planning during this period of uncertainty and flux in the transfer tax laws, because they've really enhanced our ability to plan flexibly. So I'm going to touch today on 3 state law innovations that have sort of taken off over the last 20-25 years, and how they facilitated flexible estate planning during this period, and how they may continue to facilitate flexible planning as the tax law uncertainty continues. And so these 3 state trust law innovations that I'm going to mention are self-settled asset protection trust legislation, grantor trust income tax reimbursement statutes and decanting statutes. Okay, so suppose that you're an individual who's wealthy enough to at least consider using your current estate and gift tax exemption of $13.6 million before it's cut in half. But let's say you're not a billionaire or even a centimillionaire, right, for whom giving away $13.6 million is just like a no-brainer. So you may wonder, if I give this property away, might it be possible for me to access this property in the future if I need to? Now, an estate planning lawyer might tell you that one approach is to create a trust that's sometimes referred to as a spousal lifetime access trust, a SLAT. And this is a total aside, but the estate planning community has developed like an amazing array of jargons and acronyms. So there's SLATs, there's CLATs, there's GRATs, there's CRUTs, there's CUPERTs. And I want to say, like, just this kind of overuse of jargon and acronyms has been a pet peeve of mine over my entire career. Because I think, in effect, it just has this effect of like commoditizing these planning vehicles that I think should be bespoke and tailored and to an individual client's needs into these products, you know, that some of them are trademarked or service marked, and I find it very off-putting. But in any case, a SLAT typically is a trust that a grantor would create for the benefit of her descendants, often, and in addition, her spouse. And so the idea behind including a spouse as a beneficiary of the trust is that if a rainy day arrives and the spousal unit needs access to the property that was transferred to the trustee would have the ability to make a distribution to the family, to the spouse. And once your spouse has the assets, in principle, they can be used to pay expenses of the marital unit. Now suppose that you have a couple where both spouses have sufficient assets to make gifts equal to the gift tax exemption amount. So a question that often arises is whether both spouses can establish SLATs. So I establish a trust for the benefit of my husband and my children and my descendants, and my husband establishes a trust for the benefit of my descendants and me. And this way we'll potentially have access to trust assets from two trusts should a rainy day arrive. So the potential issue with these reciprocal SLATs is the so-called reciprocal trust doctrine. And sort of very simplistically, in the case of a trust, right, established by a wife for the benefit of her husband and children, and then an identical trust established by the husband for the benefit of the wife and the children, if they're established at the same time, the reciprocal trust doctrine can step in and cause these trusts to be uncrossed, and the planning may not work as intended. Now, reciprocal trusts aside, sort of more generally, including a spouse as a beneficiary of a trust is an imperfect way to potentially get assets back to the grantor of the trust, right? For one, the spouse who's included as the beneficiary may predecease the grantor, people get divorced. So what about including the grantor herself as a beneficiary of the trust, as a mechanism to potentially get assets back to the grantor? This is where the self-settled asset protection trust innovation in state law that I mentioned before comes in. So Prior to 1997, if a grantor created a trust under the laws of any of the 50 states and retained a beneficial interest in the trust, so was a beneficiary, then under the state law, the assets of the trust would have been subject to the claims of the grantor's creditors. So, for example, if I were to have created a trust for the benefit of my husband and my children, do you have a question? Okay. So if I create the trust for the benefit of my husband and my children, and I were also to give the trustee the discretion to distribute assets to me, prior to 1997, the assets of that trust would have been subject to the claims of my creditors under every state's trust law. But then, in 1997, Alaska changed its state trust statute to permit a settlor to retain a beneficial interest in a trust without subjecting the assets of the trust to the claims of the grantor's creditors. And so individuals in high-risk professions, surgeons, and the like, started... Yeah, question?
I actually have a question. If the grantor retain any beneficial interest, or do they have to retain, is there a threshold?
So the question is, and I'll just repeat it, I said that if a grantor retained a beneficial interest in a trust prior to 1997, at least under the law of any state, the assets of the trust would be subject to the claims of his creditors. The way the state law, and you asked if there's a threshold. So the way the state laws typically work is that if you retain a $5,000 beneficial interest in the trust, $5,000 is subject to the claims of your creditors. But if you're the grantor and you retain not a fixed interest, but a discretionary interest in the trust. So the trustee has the ability to give you nothing or to give you everything. Then under the most states' trust law, the entire trust would be includable, would be subject to the claims of your creditors. Does that answer the question?
Yes.
Mike?
Well, why are any of these completed gifts for federal income tax purposes, federal gift tax purposes?
Okay, we're going to get to that. As always, Mike is like, so Mike Schler has, when I was, I think I was still an associate, I wrote a report on the New York State Bar Tax, for the New York State Bar Tax section, and Mike made the report much better because he had many questions. But you've anticipated exactly where I'm going with this. But I'll just continue and then answer your question, and if I don't, let me know. So I think surgeons and the like started flocking or transferring their assets to Alaska trusts, right, in the hopes of shielding these assets from their creditor claims while retaining a beneficial interest in those assets. And then other states followed suit and enacted their own forms of self-settled trust legislation. And we're getting to your question, but I guess the thing I'll say here is I don't know whether to characterize this development of the state trust laws as of the last 20 years as a race to the top or a race to the bottom. But what I do know is that time and time again, when I've seen one state enact some kind of favorable statute or some kind of innovation, other states very quickly follow suit. And so, let's see.
And if I could jump in real
Yeah.
quick, what's one thing that I think is interesting in hindsight, when these state laws were being changed to afford for self-settled asset protection trusts, there was a lot of focus on tort reform, a lot of public commentary about reforming our tort system. But there wasn't a whole lot of commentary, at least in the public discourse, about what was going on with self-settled asset protection trusts, which is just a complete end around any sort of tort reform, right? If these things work and you can place assets into this, again, self-settled asset protection trust, I kind of think of like placing some mansion into one of these self-settled asset protection trusts and just putting a sign out in your front yard that says, by the way, I'm judgment proof, right? Nothing you see here can be attached. But so anyway, the one happened almost like under the radar in terms of what was going on in the public debate, whereas so much attention was focused on tort reformers.
No, it's good context. But now we're going to get to, I think, where Mike wanted to take us. Right. So this is a tax law salon. Why am I talking about asset protection trusts and shielding assets from creditors? And so there's a reason. So whether a trust is subject to the claims of a grantor's creditors has an important significance for the estate and gift tax laws. So there's a revenue ruling from the 70s, Revenue Ruling 76-103, that says that if a grantor makes a gift to a trust and the assets of the trust are subject to the claims of the grantor's creditors, then the gift is not complete for gift tax purposes. And that was your question, right, Mike?
Well, my question was, even if it's not subject to the claims of the creditors, but you can still get it back, which I thought was your...
Yes.
And then it's a completed gift, even though you can get it back?
Yes.
Yeah.
If the grantor has relinquished dominion and control over the property, even though the trust assets might be distributed to her in the discretion of someone else, she can make a completed gift for gift tax purposes. Now, that doesn't mean the assets won't be includable in her estate, right? Like but the completed gift analysis turns on whether the grantor has relinquished dominion and control over the assets. And the theory, I think, right, why if the trust fund is subject to the claims of creditors, the idea is that the grantor really hasn't relinquished dominion and control over the assets because, like, it's in some ways it's within my control whether I go and get a creditor. I guess I could punch someone. I could
Just rack up a bunch of credit card debt and then send them to the
Assuming it's not subject to creditors, so you don't have that. But if you have a friendly trustee who'll give it back to you anytime you want, you can still make a completed gift and...
So if you have a friendly trustee who will give the assets back to you at any time, I suppose the IRS could assert that the transfer to the trust is not a completed gift, but where they're more likely to assert a tax or assert a tax consequence, they would say if you've made a transfer to a trust and a friendly trustee can give the assets back to you at any time, and you have an implied agreement with that friendly trustee that anytime you need money, they're going to give it to you, that would be a power or an interest that would cause the assets of the trust to be brought back into your estate. I suppose, though, if, like, where you're going, if the person is really just acting as your agent, right, they're not a real trustee, then I think the IRS could successfully assert that this isn't a completed gift because it's just you moving the money from one pocket to the other.
Say is that the documents are... I assume you would write very perfect documents.
Well,
But a lot of times, Mike, the completed gift analysis is focusing on what is the grantor's legal entitlement to direct that the trust property be. So we
Yeah.
could still have a completed gift and property being pulled back into the gross estate under 2036A1. So, but now I think this is where you're going with the asset protection.
yeah. So where I was going is right. So where I was going is, if trust assets are not subject to the claims of the grantor's creditors, the grantor does not himself or herself have any legal entitlement or ability to affect the distribution of the assets or getting the assets back himself, then now it's possible for the grantor to make a completed gift to a trust of which she's a beneficiary. And it's possible for the assets of the trust not to be includable in the grantor's estate. And so this innovation in trust law, right, which probably was intended by the state of Alaska and other states to attract business of surgeons and others who wanted to shield their assets from creditors, and like in conjunction, as you're saying, with the tort reform, this has facilitated estate and gift tax planning in a way that probably wasn't initially contemplated by the legislatures of early states that adopted the self-settled asset protection trust legislation. So what I've put here is, this is a list of the 21 states that I think currently have self-settled asset protection laws in place. And so, and I mentioned earlier that states like Alaska and others have changed their statutes to attract a trust business. So what do I mean by this? So as a general matter, in order for a grantor to form a trust under the laws of a particular state, there needs to be some kind of nexus to that state, right? And the nexus generally needs to be greater than the nexus to form like a corporation or an LLC in right under the laws of Delaware or in many other states. You can form a corporation or an LLC simply by filing a certificate of formation with the Secretary of State and naming a Delaware registered agent to whom you pay a de minimis fee each year. You can form a Delaware LLC or a corporation. Forming a trust in a particular state generally requires sort of a greater touch with the state. And so if a grantor is resident or domiciled in a particular state, then this should generally be sufficient for the grantor to have his trust governed by the law of that state. Otherwise, in order to access a particular state's trust law, the trust generally will need to have a trustee who's in that state. And so if you're a grantor who wants to form an asset protection trust, either to try to shield your assets from your creditors or to engage in some tax planning, and you're not resident in one of these states, and you don't have a family or friend who's resident in one of these states and can serve as trustee, then you'd typically hire a trust company in the state to fill this role. And trust companies, of course, charge fees, and trust companies in a number of thes states, they've like done a very, very large business over the last 20 years with as serving as the trustee to get nexus to the state with the favorable trust law. Okay, so how many of you here today live in New York? Okay, so most everybody, not everybody, but many of us. Now, suppose that you're a New York domiciled individual and you wish to use your gift and your gift tax exemption to fund a trust for your descendants right before the estate tax exemption is cut in half. But you're skittish about this, and so you also want to potentially be able to access the trust assets in the future. So having heard what I said so far, you might say, I'm going to find a trustee in one of the states that's listed here on the slide, and then I'm going to make my gift, and I'm going to have the benefit of the best of both worlds, right? I'll use my gift tax exemption, and I'll be able to access the trust assets in the future. But there's a few important caveats here. So first, the grantor, and this gets to your point, cannot just assume that she'll be able to access the assets of the trust, right? If she has a discretionary beneficiary, if she's a discretionary beneficiary, as she pleases, because the trustee, right, who has the ability to make distributions to the beneficiaries, including the grantor, needs to act independently. And as I mentioned in response to Mike's question, right, if there's some kind of implied agreement that the trustee will make distributions to the grantor whenever the grantor wishes, or the IRS kind of asserts that with the benefit of hindsight, then the trust assets can be brought back into the grantor's taxable estate. And that's the typical penalty. So that's the first caveat, right? You give the assets to a trust, even if there's a friendly trustee, you can't, they're not your assets anymore, right? And so you can't just do with them what you want. Second caveat is sort of relates to a conflicts of law issue. So, right, like New York is not one of the states that's listed on the slide that, right, allows a grantor to retain a beneficial interest in a trust and have the assets be protected from the claims of the grantor's creditors. And New York actually has a strong public policy against allowing grantors to fund trusts, retain beneficial interests, and shield the assets from the claims of creditors. And so here we have like a conflicts of law issue, right? Let's say I set up a trust in Alaska and name Alaska Trust Company as trustee, retain a beneficial interest. Under Alaska trust law, I can now transfer $13 million to the trust, and my gift will be complete under Alaska trust law because my creditors can't access the assets. But New York would say, no, we don't agree with this policy that you can deprive your future creditors of your assets by transferring them to a trust and retaining a beneficial interest. We assert that this trust remains subject to the claims of your creditors. And so this is a conflicts of law issue that's just unresolved at this point. So I think anytime a New York person establishes a trust in a jurisdiction that does allow self-settled asset protection trust, they have to understand that the trust assets may be vulnerable to the creditor claims.
Just curious if there ever been any cases where, in the absence of fraud, where a New York court just reached in to an irrevocable trust, let's say in Delaware, South Dakota, something like that?
I'm not aware of any New York cases, but there have been cases in California. There was I'm like blanking on the name, but it was a California person had created a trust in, there's one with Alaska and one with South Dakota. But there's like they're very fact specific too.
It's interesting because, sort of like a typical kind of private client is not really necessarily what I deal with, not necessarily worried about asset protection because they have creditors, but because we're trying to shield against estate tax liability. So this would mean that the service would have to sort of raise this issue. And so I'm just thinking standard family, entrepreneur, class A goes into the irrevocable trust, it's worth 10, then it's worth 250 million. But she's also the founder's beneficiary. It seems far-fetched now today that the service would raise that argument if everything else was followed.
I think it really depends. I mean, I think it in the case you were just mentioning, where the property went in and was valued at 10, and now it's valued at $250 million. Like, when the person dies, if they have a beneficial interest in the trust, that trust is likely to be reported on their estate tax return. And so the IRS could see a lot of dollars there and seek to, right?
New York or under New York law.
Yeah. I think the IRS actually is like reasonably sophisticated on this point. But that said, I'm not aware of, if we had a New York case, right, like a conflicts of law case where New York lost, that would be very helpful. I mean, just though to say it, like, for someone who is a centimillionaire or billionaire, if they want to use their gift tax exemption and be sure that they've used it, we would not recommend that they retain any sort of beneficial interest in the trust. Right. This is really more for people who are on the fence about whether to make a gift. And in that sense, it's a little bit of like nothing ventured, nothing gained, because if you're not going to make the gift and use the exemption because you're concerned that you might need access to the assets, so if you put the assets into the trust and you putting aside the fact that you may not be able to access them because the trustee isn't friendly enough, like, if the IRS ends up making the argument that the assets are still, subject to the claims of the creditors, the gift wasn't complete, the trust is in the estate, like, that would have been the result if they hadn't done anything anyway.
What's interesting is, though, with the decanting statutes the way they are, and if you have a friendly trustee, and that sort of things a lot of the corporate trustees are really friendly. So if you're working with Boston JP Morgan, they're super flexible in this type of stuff. And so, couldn't you just decant into a trust in which, surprise, surprise, the founder is now benefiting?
Oh, so we will get to decanting in a little bit, but I'll just say right now, just to answer your question, one limitation of decanting is that you can't really add beneficiaries in a decanting. So right, but let's come back to it when we cover decanting. Okay, so I think what I'll do now is, you'll see on my. Okay, see, decanting, we're going to get to it. But before we do, we'll spend a few minutes talking about the second state law trust innovation that's up here, which is grantor trust income tax reimbursement statutes. Okay, so to understand the significance of grantor trust income tax reimbursement statutes, you need to understand something about grantor trusts. This is a pretty big topic. As Professor Hellwig said, I previously taught income taxation of trusts and estates 2, and we spent 6 classes, each of which was 2 hours, on the topic of grantor trusts. How long do you spend on this topic?
I think I spent all 7 classes.
Okay. We had more, it was a full semester, so we had other stuff to get
gotcha.
to then, yeah. And I actually see a former student of mine from income taxation of trusts and estates 2, which I stopped teaching like 6 years ago in this room. So, okay, so grantor trusts are a big topic. And so for now, you'll just hear like a small sliver of it. So if a grantor makes a gift to a so-called grantor trust, the federal income tax law imposes on the grantor an obligation to pay the income taxes attributable to the trust's assets. And if the trust is a so-called intentionally defective grantor trust, and that's just again like one of these trust and estate jargony names that I hate, but like it is what it is. It's an intentionally defective grantor trust. This means that the assets are deemed owned by the grantor for income tax purposes, but they won't be included in the grantor's estate for estate tax purposes. Right? The grantor's made a completed gift and hasn't retained strings that'll pull the assets back into the trust for estate tax purposes. But for income tax purposes, the trust is like treated as basically the grantor's alter ego. So in this case, the grantor's obligation to pay the income taxes of the trust essentially permits the grantor to make a tax-free gift to the trust each year in an amount equal to the income tax liability of the trust, right? Trust earns $100 of income. Trust fund isn't diminished by paying 30% tax or 40% tax on that income. The grantor pays it. So the trust grows and the grantor's estate keeps being depleted because he or she is paying the income taxes attributable to the trust. So that's an advantage of grantor trust status for very wealthy people. They can sort of over time drain their estates by paying the income taxes of the trust, and the trust just grows unburdened by the payment of taxes. But those transfer tax benefits are not really a benefit to a grantor who's not subject to the gift tax and whose estate won't be subject to the estate tax. And so suppose we see this, that I'll pick here 2007, when the estate and gift tax exemption amount was $2 million, a lawyer, touted the virtues of grantor trust status to a client, like similar to what I just told you. And so the client made a gift to the grantor trust and was going to continue to pay all the income taxes attributable to the trust. And so now we fast forward and we're in 2024 and we have the estate tax exemption of $13.6 million. And even like when, as anticipated, the exemption amount goes down to $7 million or so in 2026, let's assume that this client who created the trust at the $2 million exemption level is, you're just not going to have an estate tax anymore. Maybe their estate's just also been drained a lot by paying the income taxes of the trust from 2007 to 2024. So over the last 20 years, right, the period on this chart, numerous states have modified their trust statutes to facilitate the ability of a trustee to reimburse the grantor for income taxes that are attributable to a grantor trust. These state law changes stemmed from a revenue ruling. It was a 2004 revenue ruling, 2004-64. And so this ruling confirmed that a trustee, an independent trustee of a grantor trust, could have the discretion to reimburse the grantor for the income taxes attributable to the grantor trust, and that due to this discretion alone, this would not cause the assets of the trust to be includable in the grantor's estate, pulled back into the estate for estate tax purposes. And so following the release of this ruling in 2004, a number of states, including New York, modified their trust statutes to, in essence, facilitate a trustee's potential reimbursement of the grantor for the income taxes attributable to the trust. And so these state law changes have been favorable for grantors who have existing trusts for which payment of the income taxes has become burdensome. And the changes also may be helpful to grantors of new trusts, right? Who they recognize the potential estate planning benefits of funding a grantor trust, that they can pay the income taxes of the trust and deplete their estates, and the trust grows unburdened by income taxes. But they may at the same time take comfort that there's a mechanism for them to potentially be reimbursed for income taxes down the line, should their cash flow or other circumstances changed.
Even though New York does have such a reimbursement statute and possibility, in your trust agreements, do you also mention this? My trustee has the discretion to reimburse the grantor.
Typically, yes. Typically, the trust.
That does not destroy any insulation from the proceedings.
So, up until it's a good question. Up until so the question is whether sort of including the clause in the trust document that so if we have state law that says that the settlor can be reimbursed or the grantor can be reimbursed for income taxes, the trustee has this discretion. Do we include this in the trust document too? And so we typically do in New York because we don't really like the way the New York statute is written. But the question is, I think this is okay in New York to include it in the trust document because New York has amended its trust law statute to say that if you have a tax reimbursement clause in the trust document, and so you can get trust assets to the grantor, that in and of itself will not cause the assets of the trust to be subject to the claims of the grantor's creditors, right? Like New York generally says if you can get assets of the trust to the grantor subject to the claims of the creditors, gift not complete, includable in the estate. But there's an exception in the New York trust statute that came in 2008 that says if the grantor, if the trustee is empowered under the trust document or under state law to distribute assets of the trust to the grantor just to reimburse for income taxes, that in and of itself won't subject the assets to creditor claims under New York law. But I think if you include this power in, and maybe this is what you were getting at, in a trust that's governed by the law of a state that doesn't have this helpful language in their statute, right, then I do think that including the tax reimbursement clause in the trust could end up causing the assets of the trust to be subject to the creditor claims of the grantor under applicable state law, and the planning could be undone.
But does this kind of provision reduce the value of the gift for federal gift tax purposes? Because you're giving less if you get back the taxes.
Are you asking whether including the provision would?
Well, would you include the provision, or it's just a right under state law?
No, so if there's no so if there were a right for, this is important, for the grantor to be reimbursed for income taxes, that would be problematic based on this revenue ruling. The revenue ruling says if there's a right under state law or under the trust agreement for the grantor to be reimbursed, that's going to cause the trust to be back in the grantor's estate. It has to be a discretionary power held by an independent trustee that will not automatically cause the assets of the trust to be back in the estate. Of course, you raise a good point. If the trustee exercises the tax reimbursement power, then the trustee is taking assets away from the trust and back to the grantor. So this is not a power that we would recommend exercising, like unless circumstances change and the grantor can't afford to pay the income taxes anymore.
Well, yeah, presumably the distribution back is income to the.
No, because
No,
a
that's a grantor
grantor
trust.
trust is a nothing for income tax purposes.
Because the grantor is already picking up the income on the trust
That sounds
assets.
too good to be true.
Yeah. That's the goal of estate planning, to come up with things that are too good.
I know. Only fools pay estate tax, I know, that's. Warren Buffett? Warren Buffett who said that?
I think it was, well,
It
I've got
wasn't
some,
Warren Buffett.
it wasn't Warren Buffett, because I think he's, I want to say Leona Helmsley, but that was only little people pay taxes, but.
Yeah, that was only the little people pay
Exactly,
taxes.
right. So Amy, just on that point, presumably the trustee is not going to exercise its discretion to reimburse the grantor for income tax liability unless the grantor wants it.
And
Right.
if it's a non grantor trust or gift tax, or there should be a gift back.
Say it one more
You
time.
get full credit for the gift without regard to that, and then if you get some of it back, it's not a gift back to you.
Well, it's just
Well, you could say it's leakage of what was
Right.
your prior intended gift, right? You're getting some of that back.
I mean, but at the
No,
same,
you're paying it back.
but you could have made the gift.
Okay.
Right.
No, but you could have made the gift when the thing was worth $2 million, and now, like your example, it's worth $250 million, and there's a lot more income than the grantor ever imagined, and at that point, he's not really worried about leakage and diminishing the value of his gift. He's worried about not going bankrupt.
Right.
Okay, so.
Especially if there's a highly appreciated asset in the trust that's about to be sold. That's when we might really start paying attention to who's actually going to incur the gift tax liability.
Or the income.
I'm sorry, the income tax liability, right?
Okay, so let's just spend a few minutes now discussing the trust decanting that you raised. So this is a state trust law innovation that just like took off over the course of my career and has been incredibly powerful in facilitating flexible planning. So what does this trust decanting mean? So the term decanting here derives from the decanting of wine, right? So like you can like decant or pour wine from one vessel to another. And so the trust decanting refers to the act of a trustee distributing or pouring assets of a trust from one trust to another trust that may have different terms. So as a general matter, like the rationale behind state trust statutes and some old common law permitting decanting is a belief that if a trustee has the authority to distribute property outright to a beneficiary, then the trustee also should be able to distribute the property in further trust for the beneficiary. This is sometimes I've heard it referred to as like the lesser includes, or the greater includes the lesser power, right? If I establish a trust for my son and the trust instrument gives my trustee this great power to distribute the assets to my son and he'll have them in his name, then the trustee should also have the lesser power to distribute the assets in further trust for my son. That's, I guess, the theory. But the decanting can be a very, very valuable tool in many situations. So just as one example, suppose that a trustee has the discretion to distribute assets of a trust to the beneficiary. But then when the beneficiary turns 35, the trust document requires the trustee to distribute everything to the beneficiary. And a lot of old trusts were written this way. So let's say that the beneficiary's 35th birthday is approaching, and the trustee has decided that it would be a very bad idea to make this distribution to the beneficiary. Maybe the trust was worth $2 million when it was funded and is now worth $250 million, and this would, spoil the beneficiary and he'll never work again. Or maybe the beneficiary has a substance abuse problem or is going through a divorce. I mean, there's just lots of reasons that you see why these big outright distributions don't make sense. So if the trustee is in a state like New York that has a decanting statute, then prior to the beneficiary's 35th birthday, the trustee can distribute the assets of the trust to another trust that provides for the assets to remain in trust for the beneficiary's lifetime. And so just based on this one example, you can get a flavor of how powerful decanting can be as a tool to modify an irrevocable trust, right? Years after it was created. So when I first started practicing, there were 2 states that had decanting statutes, New York and Alaska. And I want you to now guess, maybe we'll take how many states have decanting statutes? So like, how has this changed while I've been practicing?
50.
How many?
And the territories.
Not 50, not 50, but you're close. The answer's 38. And this relates to a question, Diane, that you were asking. At this point, practitioners frequently build into their trust documents kind of like internal decanting provisions. So you were asking about building in tax reimbursement provisions. So really, as a practical matter, right, like you have the state law, but the trust instrument can include powers that the state law does not itself include. So in all 50 states, most likely, estate planning lawyers are drafting trust documents that have their own kind of internal decanting language that may mirror the state law or be a little different. And so, right, in terms of planning for an uncertain future, like the fact that trust modification tools like decanting exist may give a grantor additional comfort in making a transfer to a trust.
Anchor. There is no such thing as an irrevocable trust anymore. It is
Well,
a title change.
That's an excellent point. So is there any such thing as an irrevocable trust anymore? Right, and as much as grantors and trustees may welcome this flexibility, the IRS and feels otherwise, right? Because you can do anything with trusts now.
And grantors may also have like.
And that's a good point.
This is the way they
Right.
want to.
Right. That's an excellent point too. I'm assuming grantors like all this flexibility, but Mike, maybe not all the trustees are so friendly, and the grantor wants something done, and the trustee refuses, and the trustee does something else that the trustee thinks is appropriate and consistent with the trustee's fiduciary duty. So I've had a few clients kind of build into the trust documents like anti-decanting language, like sort of turning off all the flexibility that state law could possibly provide. And I'll say usually like it's the clients who are so focused on having everything fine-tuned and no way to change it that like 10 years later want everything changed. I mean, it just happens time and time again. But I think you in terms of Mike, I see your skepticism, Diane, your question. I think the question is sort of, has this gone too far, right? I think the IRS and Congress may sort of not love the fact that these irrevocable trusts are so flexible and can be changed so easily. And so what's happened? So in 2011, the IRS issued a notice saying that the IRS was studying the tax implications of decanting and that it planned to publish guidance and asked for comment letters, and they rolled in. I worked on one, and the IRS said that pending the release of this guidance, they would not issue any private letter rulings related to trust decanting if there was any kind of change or shift in the beneficial interests of beneficiaries. And that was in 2011. And here we are in 2013, and there's nothing. No revenue ruling, no regulations. And for a number of years, decanting was on the IRS, the priority guidance plan, right? And so this is the plan they put out annually that lists their guidance projects that they're working on. And at some point, it got removed. So I saw someone from Treasury at an ABA meeting, and I asked, why is this removed? And she said, well, Amy, the answer is that we're supposed to put on the priority guidance plan only projects that we think we can sort of reasonably complete within a year. And we realized this is just such a big project, we don't have a time frame. And here we are, and it's 13 years later, no real guidance. So I think at this point, practicing lawyers feel like they have a good framework to analyze whether a decanting is going to trigger an income tax issue or a gift tax issue or a generation skipping transfer tax issue, which we haven't talked about today. But until Treasury issues formal guidance, there's going to at least be some uncertainty about the tax consequences of decanting and all sorts of trust modifications. And so I'll just say here, Treasury reminded us of this uncertainty with the chief counsel advice that was issued right before New Year's. It was the Friday before New Year's weekend at 5 p.m. It was like the IRS's last act of 2023. And so this is CCA 2023 52018. And this CCA addressed a topic that we previously touched on, which is the grantor trust tax reimbursement provisions, right? So I said a little earlier that a number of states have modified their state trust statutes to facilitate the potential reimbursement of the grantor for the income taxes attributable to the trust. And the CCA addressed a trust that was sightest in a state that did not have a statute that allowed the trustee to reimburse the grantor for income taxes. So what happened was the trustee went to court and petitioned the court to modify the trust, to add a tax reimbursement provision so that the trustee would have the discretion in the future to reimburse the grantor for income taxes. And as is typical under state law, when you petition a court to modify a trust, you need to notify the beneficiaries. And in this case, the beneficiaries under state law were required to consent to this modification. And so in the CCA, the IRS advised that the beneficiaries, by consenting to this modification that gave the trustee the ability to potentially reimburse the grantor for income taxes, that by the beneficiary consenting, they made a taxable gift. And the IRS said that, right, like the logic, they didn't really say all that much, but the logic is that, right, these assets previously were in a trust. The grantor was required to pay the income taxes. The assets were in the trust for the beneficiary. Now, following the modification, assets potentially could be diverted to the grantor. And so the IRS said, we think the beneficiaries have made a gift. And this is sort of notwithstanding that it was uncertain whether this tax reimbursement power would ever be exercised or how much particular beneficiaries would ever get from the trust. And so, just to be clear though, that the CCA does not say that including a tax reimbursement provision in a trust is itself problematic, or the state laws that allow tax reimbursement are problematic. What the CCA was objecting to was that sort of midstream during the administration of the trust, of the irrevocable trust, there was a change, and the beneficiaries consented and arguably diminished their own interests. So there's been an enormous amount of debate and discussion about this CCA. How do you value the beneficiary's gift? They may never get anything. The grantor may never get reimbursed for the income taxes. But I feel like this was a bit of a shot across the bow by the IRS saying, enough with you, with all the states, pandering to estate planning community and making all these state law innovations that make it possible to modify irrevocable trusts and sort of turn what was supposed to be an irrevocable trust kind of on its head and make it look very different. And we'll see what's coming. But this CCA, sort of definitely sent some shockwaves through the estate planning world.
I was thinking the CCA should have had a warning at the beginning to say, before you read this, please locate a portable defibrillator. Because it really was the IRS essentially saying, we've had enough of this, right? And we're going to put our foot down on something that I don't think anybody really expected. So.
It should be a gift either then or have it be like an open transaction and when it actually occurs, but that could be a lot more.
Maybe, although this trust had no beneficiary had a fixed right to anything. So the trustee may never have distributed anything to a particular beneficiary. How do we know if the trustee later gave assets to the grantor to reimburse them for income taxes that deprived a particular beneficiary of?
Well, that's a reason for doing it up front.
Mm-hmm.
Right.
I think there's a lot of questions, though. How do you allocate this gift tax among the various beneficiaries? I mean, these questions weren't answered in the CCA.
And Mike, that might be a reasonable approach, but under the gift tax, there's been arguments for, if we're not sure, let's just leave the transaction open and see what happens and take this open transaction approach. But that's been rejected by both the service and the courts, particularly the courts, that if it's a gift when it occurs, we don't just kind of take a wait and see approach.